In South Africa, two important new laws have officially gone live, marking a turning point for both policing and language policy in the country. These changes, while long overdue in some cases, represent a deep shift in how government institutions deal with accountability, independence, and access to services. They arrive at a moment when public confidence in state structures is fragile, with corruption scandals shaking the very foundation of law enforcement. At the same time, language rights and access to information remain central to building a fair and inclusive democracy. Today, we will take a closer look at these developments, explore how we got here, and ask what they could mean for the future of South Africa. To start, let's talk about the policing changes. The President has gazetted proclamations announcing the commencement of the 2024 Independent Police Investigative Directorate Amendment Act, with the exception of 5 sections that are not yet in force. For those who are not familiar, the Independent Police Investigative Directorate, or IPID, is the watchdog body that investigates complaints against members of the South African Police Service and municipal police. This institution has often been in the headlines because of the sensitive nature of its work. When police officers are accused of wrongdoing, whether it involves corruption, violence, or even criminal behavior, it is the IPID that must step in to investigate. The roots of this amendment stretch back nearly a decade. In 2016, the Constitutional Court handed down a ruling in a case that became known as the McBride Judgment. The case revolved around Robert McBride, who was then the executive director of IPID. The ruling stressed that IPID must be institutionally and operationally independent, free from any political interference, and able to function without fear, favor, or bias. The court emphasized that when it comes to investigating the police, political leaders, including the Minister of Police, should not have the power to interfere in matters of oversight. In simple terms, the court was saying that a body tasked with investigating misconduct within the police cannot do its work if politicians are able to influence its leadership or decisions. With this new law, IPID's mandate has been broadened. It now includes a legal duty to investigate allegations of rape committed by members of the police or municipal law enforcement, whether these incidents happen on duty or off duty. This is significant because sexual violence remains a devastating problem in South Africa, and holding officers accountable in such cases is crucial for rebuilding trust between communities and the police. In addition, IPID has the authority to investigate any deaths caused by police officers, which includes cases that happen outside of official duties. These developments come at a very delicate moment for the South African Police Service. In July this year, Lieutenant General Nlanda Mkhwanotsi made explosive allegations that a criminal syndicate had infiltrated law enforcement and intelligence structures. He accused senior leaders of colluding to weaken investigations, and even alleged that the Minister of Police, Senzo Mchunu, had personally interfered in an active investigation and worked to disband the police killings task team in KwaZulu-Natal. These are serious allegations that strike at the heart of whether the police can be trusted to serve and protect citizens. President Cyril Ramaphosa's response was swift but cautious. He placed Minister Mchunu on special leave and announced a special inquiry into police corruption, to be led by retired Deputy Chief Justice Mayeseli Madlanga. The inquiry was supposed to begin on the 1st of September 2025, but delays in securing infrastructure have pushed back the start. In the meantime, Professor Firoz Cachalia has been appointed as acting police minister. These steps show the gravity of the crisis and highlight why strengthening oversight bodies like IPID is so critical. Without a strong, independent watchdog, misconduct can go unchecked, and the cycle of corruption continues. Now, let us turn to the second major development, language rights. The Presidency has confirmed that the 2014 South African Language Practitioners Council Act has finally come into operation. This is a law that, for reasons not entirely clear, has been sitting idle for more than a decade. It formally establishes the South African Language Practitioners Council as a juristic body, giving it the power to regulate and monitor language practice in the country. The Parliamentary Monitoring Group has pointed out that this law is in line with the National Language Policy Framework, adopted back in 2013, and with constitutional obligations to promote multilingualism. The SA Legal Academy Watch also notes that the Council could help ensure equal access to knowledge and government services by improving how languages are used in official settings. For a country with South Africa's history of exclusion and inequality, this step may appear small but carries symbolic and practical weight. But one cannot ignore the elephant in the room. Why did it take nearly 11 years for this act to be operationalized? This long delay raises questions about priorities within government. It also highlights how laws that should promote inclusivity can be sidelined in the face of more urgent or politically charged issues. Still, the fact that the law is now active gives hope that language rights will not remain on the margins of policy. When looking at both of these new laws together, we see a common theme: accountability and inclusion. On the one hand, the IPID Amendment Act is about ensuring that the police can be held accountable, even when those accused of wrongdoing are in positions of power. On the other hand, the Language Practitioners Council Act is about making sure that every citizen, regardless of the language they speak, can access information and services on an equal footing. Both reflect the ongoing challenge of building a democratic society that delivers on the promises of the Constitution. Of course, challenges remain. For IPID, the test will be whether it has the resources, independence, and political backing to carry out investigations without interference. For the Language Practitioners Council, the question will be whether it can operate effectively, regulate fairly, and truly transform access across all communities. In both cases, there is the possibility of progress, but also the danger of delay, inefficiency, or political capture. Looking ahead, South Africans will be watching closely. The future of policing in the country depends on restoring public trust, and that will not happen overnight. It requires honest leadership, robust oversight, and institutions that can act without fear. Similarly, the Language Council must prove that it is not just another body on paper but a real force for inclusivity. If it succeeds, it could help ensure that no citizen is left behind simply because of the language they speak. So what do you think about these two new laws? Will they make a real difference in the fight against corruption and in improving access to information? Or will they become just more promises on paper? Share your thoughts in the comments section below. And if you found this breakdown helpful, don't forget to hit the like button, subscribe to the channel, and turn on notifications so you never miss future updates. Your engagement helps us bring more detailed analysis of South African politics and governance straight to you.